All right. Good afternoon to everybody. I'm Judge Matthew Kennelly. Welcome to court. And we're about to get going. I want to make sure that everybody is let in. You're probably seeing the two lawyers who will be arguing the first case. I promised Mr. Blumenthal that I would give him kind of a pass from not wearing a jacket because he's actually away right now and not at work. So I'm not wearing a jacket either. Let's put it that way. So my courtroom deputy clerk is going to come on in a second here. Melissa, you can, we need to let Melissa in. There she is. And Melissa, you can go ahead and call the first case. We're not hearing you.
Case 21C 5732, Business Ventures versus Market Express.
All right, this is Judge Kennelly. We're proceeding by video. Can plaintiff's counsel please give your name for the record?
Good afternoon, Judge Grant Blumenthal on behalf of the plaintiff, Business Ventures Incorporated, or BVI.
And counsel for the defendant.
Good afternoon, Judge. Richard Wolf for defendant.
Afternoon to both of you. So it's, I think Mr. Blumenthal filed the first motion. So Mr. Blumenthal, you can go ahead and go first.
Thank you, Judge. I'll refer to the plaintiff, Business Ventures Incorporated, as BVI, just to make it easier for myself. Judge, we're here before the court on BVI's motion for summary judgment for a ruling that the Illinois Business Brokers Act is not applicable to the parties' dispute. The facts of this case are simple. We have a commercial agreement between BVI, which is an Arizona business, and Market, which is an Illinois business. Market hired BVI to find a trucking company, which Market then acquired. BVI performed the services agreed. BVI then became entitled to its fee, which Market refuses to pay, necessitating the filing of this lawsuit. Market is asserted as an affirmative defense, an Illinois statute, and contends that the agreement between the parties is void because Illinois requires BVI to register, which it did not. However, the commercial agreement between the parties states, and I quote, this agreement shall be governed and construed according to the laws of the state of Arizona, close quotes. So here we have an arm's length transaction between two sophisticated business people. And generally the parties' freedom to contract is an important right that should be jealously safeguarded without court interference. This particular type of contract between BVI and Market, it is BVI's position, should be enforced as written, absent some compelling reason not to apply Arizona law. In this case, BVI submits there's no compelling reason to justify overriding the choice of law that the parties chose, Arizona law. And therefore, we believe that the application of the Business Brokers Act, which is an Illinois statute, is inapplicable to this dispute.
So here's my question. So the case law seems to say, and this is as you say, it's a question about the enforceability of this forum selection clause, but it's a sort of a quasi choice of law issue. The case law seems to say that the choice of law clause is enforced unless, at least in these circumstances, it's against or it's contrary to what's called the fundamental public policy of the state that we're in other words, Illinois. So here's my question. I mean, presumably any statute is public policy to some extent. What does it take for something to be fundamental public policy, which is what the cases seem to require?
Well, Judge, I think that the case we cited answers that question. The Potomac Leasing versus Chuck's Pub case says that the public policy consideration must be, quote, strong and of a fundamental nature, close quotes. And in this case, we're talking about the perfunctory act of just registering a business deal with the Secretary of State, filing a form. And so this perfunctory act is not of a strong and fundamental nature. And if you look at some of the other cases that we cited in which we gave examples of where courts have allowed the parties to choose their own law, to choose which law applies to the agreement, what have been considered strong and fundamental policies have been those kinds of statutes that regulate situations where there's a disparity of bargaining power between the parties. For example, an employee bargaining with their employer, or for example, a group of people that don't have much bargaining power in the negotiations. That's just not this case. As in the Potomac leasing case, where you have a commercial agreement, you have two sophisticated business people. And so the question, to answer your question, what is of a strong and fundamental nature, it must really go to the heart of, it must be something that, as the Potomac court describes, and I'm going to quote it to you, if I may.
Sure.
It's a short quote. A court should not refuse to apply the law of a foreign state, however unlike its own, unless it is contrary to pure morals and abstract justice, or unless the enforcement would be of evil example and harmful to its people.
Got it. That sounds like it might have been written in the 1800s, but actually it was written in 1987.
It's still good law, Judge. And you know, Market points out and tries to argue that the case is outdated, but it really isn't. It's good law. They've cited no case that overrides it. They've cited no case that rejects that principle. They did try to argue that there was one case where the court sets a different standard, but that case doesn't do anything of the sort. In that particular case that they cite to, the court simply says we'll apply Minnesota law because the parties agreed that Minnesota law would apply. It doesn't overrule the Potomac leasing case in any way.
So one of the arguments that Market makes is that you don't even get to the choice of law question until you have found the contract to be valid. And because the Illinois statute we're talking about, the Business Brokers Act, says that a contract that voids its terms is invalid, and I'm probably misquoting that, or void, then we don't even get to the forum selection issue. What do you have to say about that?
You know, Market has put the cart before the horse there. They've got it backwards. First, you have to determine which law applies. And then, if Illinois law applies, then the registration requirement would come into play. But you first have to determine which law applies. You have to use the Illinois conflicts of law principles analysis to determine which state's laws apply. So they got it completely backwards.
And I think you mentioned it was this non-compliance with the Business Brokers Act as an affirmative defense. I think there may also be a declaratory judgment counterclaim or something like that. Is there any violation of that statute that's, as you understand it, as you read the counterclaim and the affirmative defense, is there any violation of the Business Brokers Act that's alleged, excuse me, by Market, other than the failure to register?
They did allude to they claimed some misrepresentation. That's just a claim that they raised in their counterclaim.
Okay. Is there, just as you, and obviously I can ask Mr. Wolf about this, but what do you understand the claimed misrepresentation to involve, or is it specified?
They said that we claim to represent 3 companies, and in their opinion, we only represented one of them.
Ah, okay, okay, all right. And which the deal that's the subject of this case? It's a deal with what company? What was Market acquiring, in other words?
So, Judge, my client matches trucking companies up with buyers.
Right.
And my client publishes in various publications and describes the services that he provides. And in this case, Market saw one of those publications and reached out and said, we're interested in acquiring a trucking company. And my client went out and found a trucking company for them to acquire called Spirit. And the agreement was my client would get a fee for matching the two up. And the transaction between Market and Spirit was consummated. The deal went through. There were no hitches. There were no problems. They acquired the company, and there has been no allegation that my client failed to perform or did anything wrong. Market retained the benefit of that service and has just chosen not to pay. Now they've
And the lawsuit that Business Ventures filed in this case is to recover the fee for just that one deal, right? The one with
That's correct.
Spirit?
That
Okay.
is correct.
Okay.
That is correct. One of the things that that Market tries to hang its head on is a provision in the Illinois Act that says that any agreement that attempts to waive this act is renders the agreement void. But again, my argument is that they're putting the cart before the horse. We still have to determine which law applies first. If Illinois law applies, then the act applies. There's no dispute by Business Ventures Incorporated that if the Illinois Act applies, then we did not register. But we have to get to that analysis first using conflict of law principles to determine whether or not the commercial agreement between two sophisticated business owners should be enforced. And coming back to the original point, unless it contravenes a fundamental policy of the state of Illinois, not any policy, not any statute, but a fundamental policy, then Illinois advocates for the enforcement of the commercial agreement as written and the choice of law provision agreed to by the parties. So the real issue that I think is before this court is the perfunctory act of registering a fundamental policy of the state of Illinois.
Okay. There's no law that says you got to use up all your time. Unless you got anything else different to say, you can save a couple of minutes to respond to anything Mr. Wolf said.
I'll save a few minutes for rebuttal, Judge.
Thanks, Mr. Blumenthal. Mr. Wolf.
Yes, thank you, Judge. You can hear me okay?
Just fine.
Okay, great. I'll start with the Potomac case because I know Your Honor asked a question about that and about the standard in that case, and also the sort of fundamental public policy question. And we set forth in our briefs, Potomac is not good law when you have a statute that sets forth the policy. It may still be good law in other contexts, but the subsequent case law has said you don't apply that standard when the legislature tells you exactly what the public policy is.
It wasn't a statute. It wasn't an Illinois statute also at issue in Potomac leasing. It's the Consumer Fraud Act, right?
I don't recall that offhand, Your Honor. I know the Midwest. I'm trying to find the site, but it's the Midwest
I think it was. But anyway, go ahead and continue. That's all right.
I think then there was that the Midwest Enterprises case versus Generac Corp. At least overruled that Potomac standard as it relates to when there's clear and unmistakable language in a statute that's been enacted by the legislature. So I don't think Your Honor needs to determine, what the fundamental public policy is of the state of Illinois because the legislature has told us what it is. Right? The legislature has told us that.
So let me ask you a question about this. So basically, what you're saying is that if the legislature enacts a law that qualifies as fundamental public policy, end of story, pretty much.
I'm not sure I would go that far, Your Honor, but I think in a case like this, which is analogous to the Midwest case, when you have a statute that has kind of specific prohibitions and qualifications, and you have the non-waiver language, and you have language that agreements are void, in this case, the legislature said what the public policy is. Because they've not, the legislature has been very clear, and I think plaintiff concedes that if the act applies to it, it did violate it, okay? And just because it's an out-of-state broker does not remove itself from the qualifications and obligations of the act. And so I think what the legislature has done here is said, if you're going to come into Illinois and broker a business transaction in Illinois, you must register under the act and you must follow the act. And there's no waiver to that. And any contract that is in violation of the act is void. Any attempt to enforce an obligation that is by an unregistered broker is void. And
so
I think
that's basically kind of a longer way of saying that you can't contract your way, two business parties cannot contract their way out of this statute.
That's right. That's right.
Okay.
In this statute, yes, when there's the non-waiver language and you've got clear language that any contract is void, you can't contract around it. And the legislature has told the brokers and the parties exactly what the public policy is. And that's,
as I understand it, and you correct me if I'm wrong, because I may not have it exactly right, the business, the applicability of the Business Brokers Act is if the broker is located in Illinois, if the broker's client is located in Illinois, and is it also if the target of the transaction is located in Illinois?
correct. It's when the person engaging or seeking to engage the broker is domiciled in Illinois, which is market here, and they are domiciled in Illinois.
So let me ask you this hypothetical. I'll play a law professor for a second here. Let me ask you this hypothetical. So let's say everything is the same as in this case. You've got the business broker, which is located in Arizona. You've got the client or the customer, which is located in Illinois, as market is. But then it's the target of the transaction. The company they're buying is, let's say, in Oregon. And they enter into the same contract that says here contracts to be governed by the laws of the state of Arizona. So in that case, even though the target is located in some other state, you would say Business Brokers Act still apply. Illinois Business Brokers Act still applies, and you can't contract your way out of it.
Correct. Right? Correct. If the party engaging the broker is domiciled in Illinois, that's right. And I think what
it's not really a question that's directly presented by anything that's in here, but I just if you're talking about policy from a policy standpoint, I guess one has to sort of wonder how fundamental it would be considered for Illinois to be able to basically say, as a matter of quote unquote fundamental public policy, that anytime a company in our state is entering into a contract with a business broker, that business broker has to comply with Illinois law, even if our Illinois company says basically that Illinois law doesn't apply.
But I think
that's kind of the way this sounds to me.
I think that's a fair point, Judge, and but that's what the legislature has said. And I think there's a goal here to protect Illinois companies in Illinois, Illinois companies that are engaging a broker or Illinois targets of acquisitions, that Illinois is regulating those people who are brokering those transactions. And I don't agree with Mr. Blumenthal that it's a perfunctory act, right? There's a registration under the Business Brokers Act so that Illinois can keep tabs on these brokers and can.
Is there anything that the counterclaim or the affirmative defense alleges that Business Ventures did or didn't do not to comply with the act as it relates to this particular acquisition, other than not registering?
Well, I think Mr. Blumenthal touched on, we do think there were some misrepresentations made, and we didn't raise those in the motion because I think that would be subject of discovery, right?
But those involved other deals, right?
Well, it was kind of all wrapped up in one deal, I think, Your Honor. It was presented to us.
Can you flesh it out for me a little bit?
Sure. As I understand it, what was presented to my client was that BVI represented 3 different companies, when in fact it actually didn't. It really only represented one company. I think there's a lot of facts that would come out in discovery. I mean, frankly, my client already knew about this target. It already had a pre-existing relationship with the target. BVI was paid some amount already as part of the closing. So there are other facts at issue. I don't agree with Mr. Blumenthal that this is just a scenario where my client chose not to pay the contract and it's an open and shut case if he gets past this act.
Fair enough.
So there were certainly other issues with the transaction that will get to if Your Honor disagrees with us on the Business Brokers Act issue.
Let me ask you a question. This is out of left field. It's not part of what's presented here, but let's just say for purposes of discussion that you prevail on this. In other words, I conclude the Business Brokers Act applies, therefore the contracting around it is void, and they didn't register, and so they can't collect a fee. Is there any kind of, in some situations for like lawyer cases, for example, when a fee agreement isn't enforceable, you can still recover quantum merit. Would that apply here? I know it's not the issue that's before me right now, but I'm guessing you may have thought about it. Would that apply in this situation too?
Sure, and Your Honor, if the act applies, then what the act says is any agreement to broker these services has to be in writing. So I think the answer is no. There couldn't be any kind of equitable claim that would get you around the Business Brokers Act.
Okay. All right. What else would you like to tell me?
Judge, I just to the void ab initio argument. I know Mr. Blumenthal said we're putting the cart before the horse, but we actually do think that really does matter here, because if the Business Brokers Act applies, you really can't get around it. And what the act says is the whole contract is void. So therefore, you don't have to look at the choice of law analysis. And I think it's not putting the cart before the horse. It's a real issue that I think has to be overcome.
But it's the same question, right? I mean, it's basically you're saying that you can't contract around the act. I mean, all roads lead to Rome, I guess is what I would say. It's the same question whether you look at it up front or whether you look at it on the back end.
I suppose so, Your Honor. And I think, to that point, you ultimately do get to the same place, because if you're undergoing the choice of law analysis, there's only two factors. One is, does Illinois have a materially greater interest in the dispute, which BVI has essentially conceded, which we think every factor in that analysis points to Illinois. The Arizona court already declined to exercise jurisdiction here and really made findings about all the Illinois connections when there's virtually no Arizona connection whatsoever. And then the second point is the public policy issue. So ultimately, I think you do get to the same issue either way. And I think in sum, we think that the legislature has been clear about what's a fundamental public policy of the state of Illinois, which is that a plaintiff cannot come into Illinois, seek out an Illinois entity, solicit that entity to purchase another Illinois entity, and then claim that the Illinois laws don't apply to it. And for those reasons, we feel we're entitled to summary judgment, and the act provides for an award of attorney's fees.
All right. Thanks. Mr. Blumenthal, anything you have to say in rebuttal?
Yes, Judge, thank you. I think this case presents the question of, whether or not the court should be stepping in where two sophisticated business people agree that the law of another state controls their contract. I've cited too many cases where the courts have said it's up to the parties to decide on which state's law will control their contract. Now, you mentioned the Midwest case and asked counsel some questions about that case. And there's some important distinctions between that case and this case that I would just like to draw to the court's attention. The first is that the Midwest case was all about disparate bargaining power between two groups that had very unequal negotiating strength. But what's most significant there is that the question of whether the policy that was established was fundamental or non-fundamental was made very clear, because the legislature expressly said this is fundamental policy. It's written into that statute. And so to come back to how fundamental is it for Illinois to be telling brokers all around the country that they have to register every time they do a deal, I really do believe that this is just not anything that the legislature said was fundamental. It's nothing that they expressed couldn't be contracted around. If Illinois law does apply to this deal, then the statute applies. But here we have two sophisticated business people that decided Arizona law applies, and our position is that the courts have enforced those kinds of choices in situations that implicate far more fundamental concerns than those presented here. Judge, I would just finally end with that if the court applies Arizona law, as we've argued, market substantive rights aren't affected at all. All they have to do is pay for a benefit they receive.
Or show some defense for why they shouldn't have to pay, other than the one that we're talking about here. Okay, so I'm going to go ahead and make an oral ruling on this one, because it's a pretty straightforward and focused legal question, and I'll follow it up with a written ruling. So I appreciate the arguments on both sides. Particularly appreciate Mr. Blumenthal taking a shirt and tie with him on vacation. But anyway, so there's a contract here. There are two business corporations involved, and they agreed to apply Arizona law. And so the question is, does that get enforced, or does it get disregarded? So one of the arguments that's made by Market is that we don't even get to what would be called a choice of law question, because when you're talking about whether a contract's void or void ab initio, as it's sometimes said, you look at the law of the forum state, which in this case is Illinois. So the main case that's cited for that is a Central District of Illinois case called, I think, East Lynn or something like that. Yeah, East Lynn, Lynn. It does say that, but for that it cites, really without any analysis, a Seventh Circuit case called, I think it's called Thomas versus Guardsmark. And if you look at Thomas versus Guardsmark, it doesn't really say that. It doesn't reach that as a holding, because in that case it was essentially agreed what law would apply to determine whether the contract was void ab initio. So I think, you know, whether you look at it from the front end or whether you look at it from the back end, it's basically the same question. And the standard, as it's been stated in pretty much all the cases, is whether there's a fundamental public policy of the state, the forum state, in this case Illinois, which would override the party's choice of a particular law. There's some tension between the two Illinois cases that are primarily cited. One's called Potomac Leasing, one's called Midwest Enterprises. I don't think the second one overrules the first. That's not the way the Illinois appellate courts work. There's no binding authority here. I mean, there's district court cases, there's Illinois appellate court cases, but there's no Illinois Supreme Court case, and there's no Seventh Circuit case. When the cases talk about fundamental public policy, they make it clear that that means something other than any old public policy, and pretty much anything a legislature says is public policy. But it seems that there needs to be something more than that in order to override parties' express choice of law, particularly in a situation like this where there's no real indication of any structural disparity in bargaining power. And some of the cases talk about freedom of contract. I think that's the governing principle here. I think that the parties were entitled to contract around this Illinois statute. I think that's what they did. Under choice of law principles, I think that their choice of Arizona law governs. So I don't think that the affirmative defense and counterclaim that would require application of the Illinois Business Brokers Act applies, and that's going to be the ruling. So as I say, I'm going to follow that up with a written ruling. It'll be a little bit more detailed. I expect to do that by sometime next week, and then once I do that, I'll go ahead and set us for another status hearing where we can talk about the schedule and settlement and things like that. So thanks very much to both sides for the arguments, and I think Mr. Blumenthal and Mr. Wolf can go ahead and turn off your cameras, and then the folks in the Barnes versus Unilever case can go ahead and turn yours on. Thanks very much.
Thank you, Judge.
Okay, we got Ms. Mendoza. I think we're just waiting for Mr. Lakaitis. And Melissa, why don't you come back? Hi, Mr. Lakaitis. Melissa, why don't you come back on too, and so you can call the second case then. Great.
Case 21C 6191 Barnes versus Unilever.
Good afternoon, this is Judge Kennelly. Can counsel for the plaintiff please give your name for the record?
Good afternoon, Your Honor. Kevin Lakaitis on behalf of plaintiffs.
And counsel for the defendant.
Riley Mendoza on behalf of defendant Unilever.
All right, so just for the benefit of those who are listening, in contrast to the case that was just argued, which was pretty much a one-issue case, this is a bunch of issues in this one. And I apologize for doing this kind of late in the ball game, but I made a quick entry earlier today that basically told the parties that, at least from my end, I wanted to focus on the 12B6 arguments as opposed to the 12B1 arguments. I'm not going to preclude anybody from using time to argue whatever you want, but That's kind of where I'm focused. So it's Ms. Mendoza's motion, so you can go ahead and go first.
Sure. So plaintiffs in this case allege that they would not have purchased or they would have paid less for 2 spray antiperspirants that were manufactured by Unilever. It's a Suave 24-hour protection powder and a Suave 24-hour protection fresh. And they allege they wouldn't have done this if they'd known the results of some testing that was performed by an online pharmacy called Valisure. That testing showed the presence of benzene above the FDA standard in some, but not all, of the 4 lots of products that were tested. There's no physical injury alleged in this case. The plaintiffs allege that there are economic damages only for the decreased value of the products to them. They also assert a no injury medical monitoring claim. Now, Unilever conducted its own review and found slightly elevated levels of benzene coming from the propellant that sprayed the products out of the can of these products. An independent evaluation determined that the daily exposure to benzene from the products at the levels shown in the testing would not be expected to cause adverse health consequences. However, Unilever did decide to voluntarily recall these products. Unilever is no longer selling these products. It's offered a refund to any consumer, including the plaintiff here, who purchased the product. Again, the plaintiffs have not suffered a physical injury. They plead no facts to indicate that the products that they actually purchased contain benzene, much less benzene at a level that would increase the risk of cancer. They claim that they would have paid more for these products if they had known about the testing. They claim there is no future harm. The products are no longer being sold, and they have an easy remedy for any past harm. They can get a refund. But instead of those remedies, they filed this lawsuit. And we argue that the case should be dismissed for several reasons, as Your Honor alluded to. First, that the plaintiff lacks standing. They don't actually allege any actual injury. In addition, we also brought motions based on 12b-6 that plaintiffs have inadequately alleged the remaining 4 claims. The claims are consumer fraud, that's counts 1 and 2, unjust enrichment, count 5, and medical monitoring, count 6. We also ask that their claims for punitive damages be dismissed because they failed to sufficiently allege a basis for punitive damages.
The punitive damages isn't a separate count, right? That's alleged under, I guess, the Consumer Fraud Act claim?
That's correct.
Okay, go ahead.
I'm just going to briefly touch on the standing issue. I know that's not your focus, but
go ahead.
Some of the facts are just relevant to the rest of the claim. So the Supreme Court has made clear that to establish standing, you need to show that, among other things, that the injury in fact is particularized, meaning that it affected the plaintiff in a personal and individual way. It also has to be concrete, meaning it must actually exist. It cannot be hypothetical. For future harm, the Supreme Court has said that there's no concrete injury unless it's sufficiently imminent and substantial. Here, that means the plaintiff needs to show that the product they purchased actually exhibited the alleged defect. They do not do this. They fail to even allege that the products they purchased contained any benzene, much less at the levels that increase the risk of cancer. In the response brief, they say that they allege that their products did contain benzene, and they cite paragraphs 53 through 64 of the complaint. But those allegations do not include any allegation that their particular products contain benzene. The plaintiffs rely entirely on the results of the Valisure testing, and that testing is summarized at paragraph 35 of the complaint. But that testing does not show that the presence of benzene is uniform. 3 out of the 4 lots that were tested were near or below the FDA standard of 2 parts per million. The 4 lots that were tested all had similar expiration dates, meaning that they were likely manufactured about the same time. And if you look to the larger report that's attached to the complaint, other Suave antiperspirants contain no detectable benzene. Plaintiffs don't allege that they purchased products from the lots that were tested by Valisure, and they don't allege that the Valisure testing was a representative sample of the Suave products that they purchased. So on standing, it's just simply allegations that the products that the plaintiffs purchased may have exposed them to benzene based on tests of other lots of products that showed some, but not all, had levels of benzene above 2 parts per
So
million.
I assume that the argument that they've alleged that their product contained benzene is essentially that's a reasonable inference from paragraphs 53 and the ones that follow it. The whole thing of if I had known that there was benzene in the product, I wouldn't have bought it. Is a fair inference from that I'm saying that there was benzene in the product. If that's what's being said, what's your response to it?
That's too hypothetical to create allegations of a concrete injury. The cases have allowed plaintiffs to rely on allegations of sampling when there's uniform defects. But here, there's just no allegations of uniform defects at all, and it just doesn't. It's a sliding scale, frankly, but it's too far removed from the products that they actually purchase, and they cannot allege that the products they purchase contain benzene and they don't. What they say is, if I had known about this testing, which showed, I just described, I wouldn't have purchased the product.
Well, the things that I really want to ask you about have to do with the 12b6 part of the Consumer Fraud Act claim. But since you're on this, I guess I have to ask this. So the plaintiff says, well, we've alleged benzene was in our product, but even if we didn't, we've alleged an economic injury because if we had known that this was the type of product that is a good chance of containing benzene, we wouldn't even have bought the thing just to avoid the potential of harm. And there's Seventh Circuit cases, not all that old, including this. It's not Dippin' Dots, it's something dots though. Aqua Dots, I think, is what it's called. Dippin' Dots is the thing that's on ice cream, I think. That say that kind of injury qualifies for standing purposes. So what do you have to say about that alternative argument that they've got?
Sure. Well, I would say that the Aqua Dots case, it's not the same type of injury, because in that case, so it was a toy that looked like candy, basically, and the court found that kids thought it looked tasty, and that any parent would think there's a possibility that my kid's going to eat this toxic toy. And so that risk existed in each of the products and each of the toys that were sold. That's not the case here. We don't have, there's no uniform, there's no evidence of uniform benzene in all the products that were sold, all lots of this product. We have limited evidence.
I guess the point is that if I go to the store to buy an antiperspirant and I know that if this says, well, this might contain benzene or it might not, I'm just not going to buy the thing, or I'm certainly not going to pay $4.95 for it or whatever the price is. I might be willing to pay a lesser price, or I might not buy it at all, so I'm out money that I wouldn't otherwise buy. What's wrong with that argument?
Right. Well, it goes back to whether this testing is sufficient, whether that representative testing is sufficient to plausibly allege that the plaintiff actually would believe that. Like, if the consumer would actually believe that based on these 4 lots, then perhaps that's a good argument. Our argument, and I think it's the correct one, is that the testing here is not, it does not show that there's some sort of uniform defect that would likely cause you harm. Remember, it's not even that there's a tiny bit of benzene. That's not enough to create an increased risk of harm. You also need enough that it's actually going to create harm. There's also been a Supreme Court case of TransUnion in 2021 on standing that said that the risk of future harm is not sufficient. So
that's not this kind of case. It's not a case about purchase of a product, right? That's about credit reports.
Yes, it is. It's not a personal injury case,
yeah.
But it does make some broad statements.
Let me slide you over to the other arguments here. So,
sure.
So the two. Well, let me just kind of ask us straight out. So your argument on the Consumer Fraud Act claim, there's this what you refer to as the safe harbor argument. So there's something that says that if conduct is authorized by other law, including federal law, then it's not a violation of the Consumer Fraud Act. And then there's this question about whether there was anything actually misleading or maybe knowingly misleading here. And so here's my question for you. So basically what this boils down to on the plaintiff's side is a contention that what was being sold here was a for want of a better word, would be considered an adulterated product. In other words, something that had something dangerous in it that wasn't supposed to be there. I guess I'm having a hard time seeing how that would be protected by this safe harbor provision that says you only have to disclose the intended ingredients. Because, I mean, let's just assume for purposes of discussion that what this case was about was arsenic in the thing, and it was an oral product of some sort, and any amount of arsenic is going to kill you. I mean, and it was accidentally in there. It wasn't an intended ingredient. It would be hard to imagine the court saying in that situation, well, you've got a safe harbor from the Consumer Fraud Act because you didn't intend to put it in there, and therefore it doesn't have to be disclosed. And it just seems to me that obviously that's not this case. I get that, but it just seems to me that's a difference of degree rather than kind. What am I missing?
Well, first of all, I mean, certainly there's a case where there could be real deception, and you know, if someone knew there was arsenic in their product and they were selling the product, that would be a different case. And the plaintiffs here do not allege that Unilever had any knowledge. They expressly disclaim that that's required for them to plead their claim. So they have not alleged that there's deception, and they've not alleged that Unilever said anything affirmative that was not correct. They do not allege that, again, that any of the products they purchased actually contained benzene. So they do not allege that they were harmed. So they're missing several elements of the claim. On the safe harbor claim, there is a safe harbor which says that you can't bring a claim if what you're doing is specifically authorized by law, and that is their claim is based on labeling. You know, there really were no statements other than the label. There was no affirmative statement that the product was benzene free. So if your entire complaint, the entire count is based on labeling, and we have an very clear FDA statute on what you need to put on your label. And you can look at the label, they put it in the complaint. It's relatively simple, but that's the FDA law. You know, so to hold Unilever, the statute says you can't be held to higher standards than what federal law tells you to do. And this is a very specific issue. If they're specifically relying on labeling, we have a very specific labeling statute that tells us what we need to put on a label, and we complied with that. And they do not allege that we failed to comply with that.
And then the alternative argument is if they're relying on non-disclosure, there has to be a deliberate non-disclosure, an intentional or knowing or something like that, and they don't allege that.
And they don't allege that at all.
I'm going to have you hold the rest of your. I'm going to have you hold the rest of your time for rebuttal.
Thank you.
So I got to kind of keep on track here, given that we're starting this other thing at 4 o'clock. Okay, Mr. Lakaitis, you're up.
Thanks, Your Honor. I know you don't want to talk about standing just briefly, though. We maintain Aqueduct's hold in this case. It's a Seventh Circuit case, good authority. Defendant only cites a few out-of-circuit cases, so we stand by Aqueduct's in terms of standing.
So since it came up, what about the argument that Ms. Mendoza made that you don't really come right out and say in the complaint that the plaintiffs, what they purchased actually had benzene in it? At least that's
right, Your Honor. Yep. So, you know, the Valisher report was pretty clear. I mean, it was pretty damning. It found levels of benzene, you know, above 2 parts per million, and even in some cases 2.5, above 2.5 parts per million. So under Aqueduct's, it's the risk of harm, and you know, it's a financial injury. So had the plaintiffs known that there would be benzene in the products, or there was a risk of benzene being in the products, they wouldn't have purchased the products, so they would have paid less. So that's
really the economic loss argument for standing, right?
Correct.
Okay, but what about? I mean, because you make 2 arguments. One of the arguments, and I think Ms. Mendoza was right about this. The response brief basically says, "No, Judge, we really did allege that benzene was in what we bought. Are you alleging in this complaint?" I understand that there's some discussion about filing a revised version. In this complaint, is there an allegation that what these 3 plaintiffs actually purchased had benzene in it?
We do allege that, Your Honor. We did not conduct our own testing. Again, we stand by the Valisher report, but the plaintiffs have purchased the product on multiple occasions for a course of many years. So they were exposed to those benzene levels in the product for that period of time.
You can say anything else about standing that you want, but at some point, just kind of transition over to the other points. And I have one question for you on a topic I did not ask Ms. Mendoza about. and that has to do with the medical monitoring claim. So not on the standing part of it, on the part of it about whether it states a claim. So this is going to sound like a dumb question, I guess, but what's the cause of action is not medical monitoring. Medical monitoring is a remedy. What's the cause of action? Is it negligence? Is it something other than negligence, or what exactly?
It's a remedy, Your Honor, and I'll make this easy, that plaintiffs will be voluntarily dismissing that claim after a review of the case law and the pleading. So I'll just make that easy for you there.
Okay, that saves me a couple of questions. All right then, so we'll skip that one, and so let's why don't you focus then on the Consumer Fraud Act claim?
Do you have particular questions about that, Your Honor, or some points that you're?
Basically just the same things I was asking Ms. Mendoza about. So there's this argument about the safe harbor. It's really two things, I think. It's this argument about the safe harbor. In other words, the contention is that, you know, federal law says we only have to disclose what we intend to put in the product. There's no contention we did anything other than that. And end of story, safe harbor under 10B, Section 10B of the Consumer Fraud Act applies. That's the one. And then the other point is that, well, if the contention is that your way around the safe harbor is a non-disclosure under the Consumer Fraud Act, there has to be some level of knowledge in terms of the non-disclosure, and that's missing. So I deal with those in whatever sequence you want.
Sure. So I think it's easier to talk about the safe harbor first. I think first that's an affirmative defense, which is typically not decided on a 12B6 motion. But even if Your Honor does want to consider it, Your Honor, you hit the nail on the head where the products are adulterated and mislabeled under the regs that we cite in the complaint, and therefore, just by having the benzene in there, the products are adulterated, and therefore the safe harbor doesn't apply. And our case is based on omission.
I'm sorry about all that honking. That's a fire engine going past the courthouse. Sorry about that.
So our case is about omissions, and that's the basis of our ICFA claim. And there's two ways that you can plead an ICFA claim, and that's under the unfair conduct prong or the deceptive conduct prong. And plaintiffs here adequately allege cause of action under each prong. The difference is under the unfairness prong, it's analyzed under Rule 8. So you don't have that Rule 9B particularity standard. And plaintiffs here sufficiently allege that Unilever's conduct was unfair. And to determine whether a practice is unfair, Illinois looks at whether it offends public policy, the conduct is immoral, unethical, oppressive, unscrupulous, or causes substantial injury to consumers. And we believe that Unilever's conduct fits all of that, but we only have to actually allege that we meet one of the factors. But by putting benzene in the product, we allege that it was avoidable. Unilever did not have to use this. There's no therapeutic benefits to this whatsoever. They should have conducted testing before placing this product into consumers' hands. It's a really serious issue. Benzene is carcinogenous. It can cause cancer, and it's something that you're using every day on your body, on your skin. So therefore, Unilever, placing this benzene in the product, not testing it, that's sufficient under the unfairness prong. We also allege that Unilever's conduct, the omissions, not disclosing the presence of benzene in the product, was deceptive. And the difference between the unfairness and the deceptive is that under the deceptive prong, it is judged under Rule 9B, Your Honor, but knowledge is not judged under Rule 9B. It's judged under Rule 8, where you can allege knowledge generally under Iqbal. And I believe one of Your Honor's cases, Wong versus Whole Foods, also held the same thing. So, again, we allege that Unilever should have known and should have done testing prior, during the assembly line process. They could have done testing there, even in the formulation, development of the product. Other companies are not using benzene in their deodorant products. Unilever is a huge
Can I interrupt
corporation.
you with a question? So one of the things that Ms. Mendoza says is if what people are relying on is this testing report. the amount of benzene that's in it is not enough to harm anybody. What do you have to say about that?
Not what the FDA says, Your Honor. You know, they don't. FDA says no levels of benzene should be in the product because it's not safe. And then if it's for therapeutic use, 2 parts per million. And the testing showed over 2.
Benzene, I'd never heard that one before.
It was, and I might have misspoke, Your Honor. Give me a second here. It was
okay. I mean, it may be. I just know my last memory of benzene is high school chemistry class. So
I may have misspoke. It's the therapeutic use of the product, so not the, the product itself. Benzene is not therapeutic whatsoever. It's very dangerous.
Your point basically is that there's no such thing as a safe level.
Correct, Your Honor.
Okay. Let me ask you a different question, related but different. So on this unfair practices part of the Consumer Fraud Act, as opposed to the deceptive practices part, I mean, I guess the way I kind of read the complaint is that you're putting this product out there that you haven't really adequately tested and has a dangerous chemical in it. That's unfair. Is that a fair reading of at least part of what you're alleging here?
That's fair, Your Honor. And also the complaint at paragraph 9, where plaintiffs allege that the use of benzene was avoidable and that there were alternative formulations, design, materials that were available to Unilever at the time that it had formulated and designed and manufactured the products, yet they still ended up putting benzene in the products before placing it into consumers' hand into the stream of commerce.
Okay. All right. You've more or less exhausted my question. So what else would you like to tell me?
That's it, Your Honor, unless you have any other specific questions. Unjust enrichment, we allege, plaintiffs maintain that we allege a claim under the ICFA, and therefore we allege a claim under unjust enrichment, which is a theory of recovery. It's not an independent claim under Illinois law, but it's a theory of recovery. So we believe that we have stated a claim there. And then the punitive damages issue, I don't believe Your Honor touched on that. Is there a specific question about that, or?
No, there really isn't. I have a different way that I think I'm not going to rule on that issue now, but I'm going to come back to it a little bit. Let me ask you one other question just about procedure, and you alluded to this earlier, and just so those are listening know this as well. So I think it's right now 3, maybe 4, but I think it's 3 cases, all of which allege the same thing that have all ended up in front of me because this one was filed. And after I had set the briefing schedule on this and set it for oral argument, there was an indication on the plaintiff's side that an amended complaint was going to be filed. And I said hold off on that because my somewhat educated guess, assumption, whatever you want to call it, was that some of the same issues would come up again and it would be beneficial to go ahead and deal with them. So that's why I'm not going to bother asking you about the medical monitoring claim. But pardon me. How close are you guys to being? How close are you folks to being ready to file an amended complaint? Once I tell you, okay, you can go ahead and do that.
Yeah, I mean, we can file within 30 days, Your Honor. I guess it depends. Right. Do you intend to rule first and then we would amend? And
I get it. So you'll need about a month. That's a fair point. Okay, Ms. Mendoza, is there anything that Mr. Lakaitis has said or anything that I said when he was talking that you want to reply to?
I would just push back a little bit on the unfair acts part of this this claim. I mean, this is they allege a deceptive act, and they did use the word unfair a few times in their complaint, but what they've actually alleged is a deceptive act, and so it should be held to the higher pleading standard of Rule 9b. And I think the efforts they are making to try to get away from that standard show that they do not.
Here's what I see as the problem with what you just said on a 12b6 motion. They've clearly alleged both, and there's no requirement at this stage that they pick one or the other. You can do it in the alternative. So it just seems to me that if I ignore the references to unfair practices and read this just as a deceptive practices claim, it runs directly contrary to the rule that I'm supposed to read the complaint in the light most favorable to the plaintiff on a 12b6 motion. What's wrong with what I just said?
What's wrong with what you just said is that when you're alleging deception or fraud, you need to meet a higher standard, and you shouldn't be able to avoid that higher standard just by adding a couple words to the complaint when there's no actually allegations of unfair practices. The way we read the complaint is that they're alleging deception, and they don't allege that we actually deceived anyone. And we don't believe that meets the standard of Rule 9b.
Okay. So there's a bunch of issues in this case, and I kind of want to walk through them. And as I said in the last case, I'll have a written order, which is probably going to be somewhat longer than what I'll say now, but just to kind of walk through them. So there's a bunch of standing arguments. The first is that there's no injury in fact. I agree that it's not really clearly alleged in the complaint at this point that any of these plaintiffs suffered an actual physical injury, but the law is clear that's not required. Economic injuries are sufficient, and of course they are, because breach of contract cases and promissory fraud cases can be filed in federal court. And if this benefit of the bargain theory that the plaintiffs alleged didn't work, then all those cases would go out too, and I don't think anybody's suggesting that. The Aquedots case, which is, I grant you, 10 or 11 years old, and there's been some other Supreme Court cases since then, but I think that's pretty darn close to this, and I don't think it's undermined by the Supreme Court cases, particularly the TransUnion versus Ramirez case, which was cited. And there's some more recent cases, the one that I thought was persuasive out on another circuit that was cited called D. Bernardis, D-E-B-E-R-N-A-R-D-I-S, out of this 11th Circuit, which basically says the same thing. The second argument is that there's no standing for injunctive relief. I agree with that. The Seventh Circuit case that governs that is a case called Camasta versus Joseph A. Bank, C-A-M-A-S-T-A. There's some arguments made to distinguish it. I don't think they really carry the day. For the Supreme Court's made it clear that you have to have standing for each type of relief that you're asking for, and this would require some form of future injury. And I don't think that that's really alleged here. And that the possibility of some future deception doesn't appear to be enough under the Supreme Court cases to count. There was a standing argument on the medical monitoring claims. I know those aren't going to be replayed, but just in case, I think the judge, I hope he's listening, I think Judge Valderrama's opinion in Leslie versus Medline was pretty persuasive on both actually the standing and the failure to state a claim issues. He found there was standing from the exposure to a dangerous chemical because there is some only microscopic effect. So I think there was standing on that too. Flipping over to the failure to state a claim issues, there were some warranty claims which the plaintiff basically didn't defend, at least in this version of the complaint. So those will be dismissed. On the punitive damages, so it's a choice of law issue, and there's a bunch of different classes that are identified here. There's a proposed nationwide class, there's proposed statewide classes, and I can imagine the punitive damages choice of law question being different depending upon what, if any, type of class gets certified. So I think it's not going to affect discovery much, if at all. It's basically there's a little bit of net worth discovery that have to be done. That can be deferred anyway. I think that's a question better decided at a later stage of this case. Just very quickly to say on the merits of the medical monitoring claim, I agree with Judge Valderrama's opinion in the case I just cited, that there has to be some actual current physical injury, which I don't think is alleged, at least well enough in this version of the complaint. Increased risk of future harm by itself isn't enough under the leading Supreme Court case from Illinois on this, which is called Berry, I think Berry versus City of Chicago. On the unjust enrichment claim, I can't say at this point that it's a complete duplicate of the other claims. I think people are allowed to plead in the alternative. I'm not inclined to dismiss that at this point. And the big kahuna, if you will, on this one is the Illinois Consumer Fraud Act claim. I think that, and although Ms. Mendoza has a point when she says that the claim seems to be more aiming at the deceptive practices, I think you're allowed to do an either or. I think there's enough references to unfair practices, although it could probably be done a little bit better. And it just seems to me that it would be a viable unfair practices claim to allege that you're putting a product that people are going to put in or on their bodies out into the market without doing adequate testing, and it's adulterated by a carcinogen is likely enough for an unfair practices claim. The safe harbor issue is, the plaintiff's right that affirmative defenses don't always or don't typically get decided on 12b6 motions, but they can be sometimes if it's clear that there's no way around the defense. And this is kind of pitched as purely a legal issue. I actually think that's one that's going to benefit from further briefing once we get the amended complaint filed. So what you're going to get from me in the written order is something that basically says, I agree with these standing arguments by the defendant. I disagree with these. These claims are deficient under the current version for such and such a reason. These claims aren't. I'm deferring a couple issues, kicking them down the road, and then probably giving the plaintiff 30 days to file an amended complaint. So I'll try to get that out within the next, hopefully no more than a week or so, and then I'll set it for a status hearing and we can figure out where to go from here. Much appreciated to both sides for your arguments. You were very responsive to questions. I really appreciate that. It was just as were the lawyers in the earlier case. So thanks very much. You're welcome to listen, but you should turn off your cameras at this point.
Thanks, Connor.
All right, take care. And then Carolyn, you can cut off the court reporting part of this. And I guess Lisa Jackson, if you can turn on, hopefully Judges Valderrama, Rowland, and Joel Skinner, and Judge Harjani. And I am going to change out of this robe and into a jacket very quickly here. Okay. Hi, Mary. I got Judge Harjani. Just waiting for Judge Harjani here. I saw him for a second and then his box went away.
Yeah.
While he's signing back on, the other, oh, there we go. Good. I've got everybody. Okay, so the non-judge face that you see on the screen is Joel Skinner, who's with he's a past president of the Federal Bar Association, which is sponsoring this event. And Joel, go ahead and take it away.
Thank you, Your Honor. My name is Joel Skinner. I'm a past president of the Federal Bar Association Chicago Chapter, as I'm proud to say is Judge Kennelly himself. Before we proceed to the second part of today's program, I'd like to take a moment to strongly encourage you to become a member of the Federal Bar Association Chicago Chapter. Membership in the FBA has many benefits indeed. As with today's program, our federal judges participate in most of our programs. Our chapter is distinguished, in fact, by the high level of involvement of our federal judges. Membership in the FBA is a great way to get better acquainted with our local federal judges. We're pleased to offer today's program, as well as many others, completely free of charge. While there is a fee associated with many of our other programs, these fees are truly nominal, especially when compared to those of other bar associations. Most significantly, the Federal Bar Association's annual membership dues are far lower than the dues of the American Bar Association, the Illinois State Bar Association, the Chicago Bar Association, and others. For example, for young lawyers, the annual dues are only $90 for public sector attorneys and $115 for private sector lawyers. As to the law students in our group today, such a deal, $20 annual dues for 1 year, or $50 for law students who are in their first year, and that gets you a full 4 years of membership. A great deal financially. We offer robust programming for younger lawyers and have law student chapters at all of our local law schools. So, in sum, I enthusiastically encourage you to join the Federal Bar Association Chicago Chapter. It's very easy to do so by simply going to our website, which is fedbarchicago.org/membership. Again, that's fedbarchicago.org/membership. www.judgekenneally.org/membership. Thank you very much for your kind attention. Please allow me now to turn the program back over to Judge Kennelly for the second half of our program. Enjoy.
Thanks very much, Joel. I won't spend more than a couple minutes introducing my colleagues who are on the panel today, other than to just very much thank them for their participation. So we've got Judge Mary Rowland, whose career track is federal public defender, private practice, where she did both civil and criminal cases, federal magistrate judge from 2012 to 2019, and she was, I think, one of the last judges appointed before the pandemic in the fall of 2019. So she's a district judge now. Judge Franklin Valderrama, career track is, I think, private practice with the law firm of Sanchez and Daniels, Circuit Court of Cook County, where he, I believe, ended up in the Chancery Division in his last years over there, and he was appointed like right smack in the middle of the pandemic in this court in September of 2020, and I hope his ears were burning when I was citing his opinion a few minutes ago.
They were, thank you.
And the last but not least is Magistrate Judge Sunil Harjani. Judge Harjani has been a magistrate judge since 2019. I believe he started out at Jenner and Block and then was with the Securities and Exchange Commission and then was with the U.S. Attorney's Office here in Chicago for an extended period, including a period where he was head of the Securities and Commodities section where he did complex white collar cases. So thanks to all of you for joining, and just kind of jump right into this. So we're now 2.5 years-ish into the pandemic, and I guess what I'd like to start off with, and maybe with Judge Rowland, is since you've been a judge kind of both before and after, how has this affected your work as a judge, how you manage your cases, how things run, and is it good, bad, or indifferent? Go for it.
Oh, awful. So it seems to have a greater impact, I think, on the court, and a longer lasting impact on the court than on our regular lives. You know, most of us are back out going to dinner, traveling a bit, going to concerts, things like that, but still in the court, we're still have a lot of precautions, which I think is necessary, and particularly when we're talking about jury trials. Judge Kennelly can talk more about this really than any of the rest of us can, but and we are largely still doing all of our status hearings. You just saw Judge Kennelly do a motion hearing, and that is all being done by video. And before the pandemic, all of that was done in court live with judges. This panel would be live. We would all be in court. We'd all be together, and we'd be sitting around a table talking. So the difference is doing things either by video or even worse by phone, where you can't see the lawyers and make eye contact with them. And that I find very frustrating in civil cases and particularly in criminal cases.
You think it's going to go back at some point, and if so, when?
Well, Judge Pallmeyer is predicting that the pandemic will be over on the last day that she's chief judge. So we're looking forward. We don't want her to quit being chief judge, but we're looking forward to that day. I think it's going to be really hard to go back because I think lawyers now are very used to attending by phone. I think it's going to be hard to get people to come back into court. We're in court. You know, we're there. I see you three are there. I'm actually home with COVID today, so that's why I'm not in court. But I think it's going to be hard to get people to come back to the courthouse. But I think we're missing out on so much by not being in court. I mean, I guess if we enter orders saying it's in court, you know, lawyers will come.
Yeah. Judge Valderrama, you weren't at 219 when the pandemic started, but you were in a court which is all in person as well. How has this affected things as you see it?
Well, I certainly echo many of, if not everything that Mary just said. You know, when I was in state court, which was during the onset of the pandemic, we had also kind of gone from a lot of in-person to then virtual proceedings, and then certainly coming here to 219, it's been all virtual since I've literally been here. But I will say that I think, like Mary said a moment ago, I think the status reports that the parties are now accustomed to providing the court are really going to remain with us and be a way of keeping us informed as to what's going on with the case. And it's a cost-saving measure, I think, for a lot of the attorneys. That's why they also like to do it. But one thing that I do miss is I do miss the in-person, face-to-face interaction with the lawyers. And that's something that's been the case for my time at, the Daily Center to the short time I've been here, is I really miss having the in-person dealings with the attorneys.
So before I give this question to Judge Harjani, I want to throw in a couple of other things just to pick up on a couple of points that Judge Valderrama and Judge Rowland just made. So our court, as I'm sure everybody on the panel knows, it was different before the pandemic. Was different from virtually every other federal district court in the country in the sense of the number or the quantity of in-person proceedings we did. The way we've been doing things during the pandemic is to some extent the way most federal courts were doing it before. Status reports, phone calls, things like that. As I've thought about this, and an argument can be made that, as Judge Valderrama suggested, from a cost standpoint, we're saving people massive amounts of money and time and effort by doing it this way, because for that 5-minute status hearing, it's a 2-hour commitment of time. You got to come downtown, you got to go through security, you got to get dressed up, at least all the way to the floor as opposed to from the waist up. Let's leave that there. And all sorts of other things. So Judge Harjani has been a judge since both in this building since both before and after. So talk about how it's changed things from your end, and also see if you can maybe work in this question of what happens in the future.
Yeah, I think to add to Judge Rowland and Judge Valderrama, where I have the greatest concern is with respect to criminal cases. So I tend to see people who get arrested. I'm the first judge they usually see when I'm on criminal duty. And I think about myself, if I got in trouble and I was, charged with something, I would want to meet my lawyer that very day, that morning. I would want to see the judge who is advising me of my rights. I would want to face the judge who is deciding whether or not I am going to be released on bond or detained for potentially a year or 2 years while awaiting trial. Those are all really important things that happen right when a person's arrested and within a few days of an arrest. And we've been doing all of that mostly by phone, sometimes by video, but when it gets really busy and you have 7 or 8 arrests maybe in a day, it's easier to do it by phone. And I think a lot has been lost in that process in terms of people's ability to have faith in our justice system, in our criminal process, their ability to interact with their lawyer and receive counsel, to come to court and know who their judge is. So I think the thing that won't change, that will change, hopefully, is that we will go back to in-person criminal proceedings, particularly when a person's first arrested. Obviously, they're having a jury trial in person. In the middle, they are having a lot of phone statuses. But at the very beginning of the process, I think we need to go back soon, hopefully, to in-person proceedings.
Let me pick up on that point and kind of stick with this question on the criminal front. So for those in the audience who don't know, so there's certain things in criminal practice that by rule had to be done in person, the kind of thing that Judge Harjani was just talking about, but most particularly sentencing hearings. And there was a law passed right at the beginning of the pandemic that gave us the ability to do those kinds of things virtually if the defendant agreed to it. So going to sentencing is kind of the other end of the process, the back end of the process from what Judge Harjani just talked about. I was a criminal defense lawyer. Judge Rowland did that kind of work as well. I would have thought that every criminal defense lawyer, once we had the ability to do these things in person, would be saying, I want to be there in person, I want to be there in person, I want my client there in person. For me, at least, it has not worked out that way. I'm still seeing at least half and probably a little bit more than half of the sentencings where the defendant and the lawyer are all agreeing to do it in person. And I have to say, I'm not quite sure why, and I'm thinking that maybe just people have gotten used enough to this and they're comfortable enough with it. Judge Rowland, do you have any thoughts about that?
Yeah, and Judge Kennelly, I think you misspoke. You said they're agreeing to do it in person, and I think you meant—
I agree to do it by video. Yes, by video.
Yeah.
My mistake. Thanks.
No, I agree. And I'm actually saying, we're going to do this in person, right? I want to do this in person. So I'm kind of encouraging them to do it in person, mostly because I want to do it in person. But I agree with you. The lawyers, the criminal defense lawyers, to my surprise, are comfortable. And I think you're right. I think there's just a comfort level with doing these things, with doing court virtually. What I really don't like is doing sentencings where the defendant is locked up. So the lawyer is not with the defendant. The lawyer is in his or her office, and then the prosecutor is wherever the prosecutor is, and then, I'm wherever I am. So I've been, saying, well, we're doing this in person. And then I think the lawyer has a harder time saying, well, Judge, we're comfortable doing it remotely. So I've been kind of insisting that we do it in person, although they do have the right to waive that. But right. I agree with you. I think, well, I like doing them in person anyway.
Yeah. One of the reasons I actually haven't done what you've done, in other words, trying to weigh in on it, and I don't know that this is still true or not, but there was a significant period of time for people in custody where if they came out of jail, when they went back in, they were considered to have been exposed and they were put in quarantine, in other words, in isolation, the hole, or whatever you want to call it. And I really didn't want to impose that on people. Honestly, I'm not sure that's still happening, but
I don't know if they can do that anymore. Yeah, that's a good point.
Judge Valderrama, do you have any thoughts about that, the sentencing aspect of it?
Well, yeah, first of all, I agree with Mary that and with you, Matt, that certainly in person is preferred. I was operating under the same assumption that you just mentioned a moment ago, and that is that sometimes when a defense attorney declines to do it, have the person in person for the sentencing, I require them to say that they've had a consultation with the defendant, and this is what the defendant wants to do. And oftentimes it's exactly for the reasons that you, Matt, and Mary have suggested, which is, I don't want to deal with the quarantine, so I'll just do it virtually. I would probably say it's been 50-50 in terms of 50% come in and 50% want to do it virtually. So that's been my experience.
Yeah. Let me go back to Judge Harjani and just turn this question a little bit to something that Judge Harjani spends a lot of his time doing, and that's settlement conferences. So the conventional wisdom, from time immemorial to 2.5 years ago was that you had to have the people there in person to do an effective settlement conference. So number one, how's that conventional wisdom proven? And number two, if doing okay on settlement conferences by video, are you planning to go back to doing them the other way? And if so, what's the trigger going to be?
Yeah, I think, when the pandemic hit and we were forced to all go from 100% in-person settlement conferences, I had never done one virtually prior to the pandemic, to 100% virtual settlement conferences. There was a lot of nervousness and trepidation as to whether or not they would be successful. Because of the conventional wisdom that you mentioned, Judge Cannelli, I think that conventional wisdom is thrown out of the window now. I think they honestly work almost as, if not just as well, as in-person hearings. I calculated my settlement rate prior to the pandemic, and when it was 100% in person, and calculated for during the pandemic when it was 100% virtual. And there was no change in the rate of settlement of cases, which is a good rate, as is for all my colleagues in the Northern District of Illinois. We settle the vast majority of our cases, and the ones that don't settle at the conference settle at the next conference, or a little bit a month or 2 or 3 months later after something happens, a plaintiff's deposition, a ruling on summary judgment, etc. But the rate has not changed. So that's one data point, if you will, that tells me that they work just as well. I think lawyers think they work just as well. I have tried to get people in, and they call my courtroom deputy and say, can we do this virtually? And they're very comfortable with it now for many reasons, including the fact that it's easier to schedule. Even if the lawyers are in Chicago, their clients are often out of town. The in-house lawyers or the individual client or the insurance carrier are generally not here. And so travel and schedule, I think, are the two biggest primary drivers of people wanting to do virtual settlement conferences, particularly now that almost every lawyer involved in this kind of commercial practice has done one, and they've had success with it. I get to hear a lawyer tell me they have not been successful, so they have a good feel that it works. And so I think they're very comfortable. I'm certainly very comfortable. And if I were to predict going forward, if we could all go back in person tomorrow and I said, please come in for in-person conferences, my courtroom deputy's phone would be ringing off the hook. I think just about everybody would start asking and making motions for virtual conferences.
Wow.
Yeah. That's, I don't do anywhere near as many settlement conferences as a magistrate judge, but I do probably more than some, at least some, or maybe more, most district judges. I've found exactly the same thing. It's maybe one factor, but all of the other reasons why people settle or don't settle are all still there. So, and that there's this comfort level.
Okay, I've done 3 virtual settlement conferences. I've settled 0.
Well, it's just because you're not that great at it.
I know. I'm so embarrassed.
So, yeah, so that's, I guess the question is that, so let's say that, a month from now, all the variants have been determined to have disappeared from the face of the earth, and we're declared by the World Health Organization or CDC or whoever that there will be no COVID anymore. So is what you're saying, Judge Harjani, is that you would probably still give people the choice? Or I don't want to make you commit. There's a privilege for these things that they can't be used against you later, but what do you think you do?
I think for the majority of cases, I would likely still do virtual. I have pre-calls with lawyers before I set a conference. So that's a good place where I would sound out and see what people think. And see what their comfort level is. For the most part, they have asked me, Judge, can we do this virtually? Even though, we are all doing it virtually, they still ask to do it virtually. I think there are a small group of cases where in-person is really going to make sense, particularly difficult clients that need a lot of interaction with the setting of a courtroom and the judge, and to understand the gravity of the situation. Sometimes you need to be able to pull people aside, especially lawyers, into the hallway. That's much easier to do in a very casual fashion than moving someone physically to another breakout room. So there'll be cases, I would say 10%, where I could see in-person conferences, but I reckon, I guess, because of scheduling and travel, 90% would say virtual.
Let me just say 2 things to the audience. So number 1 is, I'm going to give you the CLE code at some point, but the rule is we give it out at 4:45 so that you all don't leave. That's number 1. Number 2, if you have questions, send them to there's a questions tab or something like that. Those get forwarded to me. There's one out there right now, which I've got. I'm going to hold it till a little later just in terms of the sequence of things. So let me just turn to a different question now. So, and these are all kind of basic, civil practice or criminal practice type questions, because we've got an audience largely consisting of law students and newer lawyers. But what are the things, and you can make this in person, you can make it virtual over the phone. What are the things that lawyers do that make it, that not so much tick you off as it make it hard for you to do your job well in any of these, whether it's an in-person hearing or a phone hearing or a video hearing or anything like that? Let me start with Judge Valderrama. And you can draw from any experience you've got, obviously.
All right. So I think the things that would tick me off and do tick me off, I think segues nicely with what you were just saying, Matt, is the technology issues is, for example, either coming on late, if it's a telephonic status hearing, or even by video, coming on late, not letting us know that you're going to be coming on late, having issues on your end with your technology, and then we're waiting for you to be able to join the call. We put in our minute orders that you should try to, test your technology about 10 minutes before the call to make sure that there are no issues, and go from there. That has worked the majority of the time, but the times that it hasn't worked, it's been more than a few minutes that we've had to wait for that to get resolved. So that's one of the things that I would say that would tick me off, and that's more based on technology than
Tech,
anything the
right.
attorney has said. I can go on in terms of beyond that if you wanted me to, but that would be a link to what we were just
So
talking about.
the idea is we're 2.5 years into the pandemic. It's your home internet ought to be working by now.
Yes, yes. You should have no issue with the filters. You should be able to get on without any problem.
Judge Rowland.
So I'll just follow up on the thing is, you're coming to court. And, you know, for those of us who are a little longer in the teeth, you're coming to court. So I know our audience here is younger, and that's great because we need young, bright lawyers, and you're going to save us from ourselves, I'm sure. But you can't be, you know, playing music in the background or driving and honking the horn. You're in court. And all of these things are happening. I mean, so the court reporter is trying to take down what's happening in court, and there are these background noises, and it's making it hard for the judge to pay attention. It's making it hard for the other lawyers to pay attention, and it's making it hard for the court reporter to get, you know, down what's happening. And I do think that because particularly younger lawyers haven't been in court, haven't been going to court for 20 years, and because we're all virtual, there's a little disconnect with, you have to take this seriously. And I've had lawyers say, well, Judge, I don't have my notes in front of me, so I'm not exactly sure. I can tell they're driving. I can hear the blinker going. And I'm sitting at my desk with the notes for the case in front of me, and I'm thinking, well, I'm more prepared on your case than you are, because I'm looking at the docket and I've got notes, and I'm thinking, well, I shouldn't be caring more about the case than you do. This is your case. This is your client's case. So it's not, you're in court. Just, that's all I can say. You should be at a desk. You should be quiet. You should be paying attention to what's happening. Just as if you had to walk over and go through security and come up to the courtroom. It's great. You don't have to do that. It's great. You're saving time and money. But you should take the 10 minutes out to be at the hearing. You shouldn't be on your way to the gym or on your way to Starbucks or in a Starbucks line calling into court, because it's mostly because it's disruptive to everybody else. And it happens more than you think.
Yeah, I think that's a great message. Even if you're not in court, treat it like you are in court. I can't tell you how many times I've done phone statuses where people, I am 100% certain they are in a Starbucks line, because I'm hearing people calling out, you know, vanilla latte in the background. So.
Right. And the judges, I'm telling you, we would not do that. We would not be going through the Dunkin' Donuts line, calling in, because it would be disrespectful to you, to your clients and to your cases. And that we don't want to send that message to you or to your clients. So, you know, you have to do the same. And you're just getting out to your practice, so just start that early, regardless of how your practice is going to be. Can I say one more thing about pet peeves, though, Judge Kennelly?
Yes.
I used to go to these kind of seminars. I used to go to these kind of seminars to figure out what are the pet peeves, because I wanted to be a good lawyer. And I remember Judge Kennelly at one of these things saying he had a pet peeve. This was when we went to court, where lawyers would shake their head yes or no when someone else was speaking, like they were disagreeing with an argument, and they would shake their head no because, you know, they didn't like that argument. It was distracting to him. And I thought, oh, note to self, stop shaking your head in court, Mary, you know, because it would aggravate Kennelly. So don't do that in Kennelly's courtroom, because I would do that. You know, the prosecutor would be making an argument. I'd be over there shaking my head like, no, that's wrong, that's wrong. And I got to say, when I'm in court, when I have real people there, it actually kind of helps me when I see a lawyer shaking their head, because I think, oh, I need to go back to them, like they want to respond. There's some body language telling me somebody has something else to say, and it's a reminder. And I don't have as quick a mind as Judge Kennelly, so I need reminders.
So the real message here is don't pay any attention to what Kennelly says.
Well, there's that. Don't listen to Kennelly. But with that, what I say really is every judge has their own particularities. So it's really good to hear what pet peeves are, but you kind of can't win, because things that irk some judges don't irk other judges. And so I always remember that, because I thought, oh, now I kind of like when people shake their heads. But I just always that from a panel I went to.
I remember from the days I was appearing in the criminal court that in the state court, there were certain judges that you must stand behind the podium. There were some judges like you don't want to stand behind the podium. You can't stand behind the podium. Or you have to sit here. You have to sit there. And like keeping the book on all that stuff was virtually impossible.
You can't
So
win, yeah.
clearly right about that. Judge Harjani, thoughts about things that people do that are not effective. And if you want to talk about settlement conferences, great. If you want to talk about other things, either or is fine.
Yeah, I think, like Judge Valderrama and Judge Rowland, the real downside of doing so many video and phone hearings is people have forgotten a lot of the courtroom etiquette and traditions that come with our courthouse. Most people who practice in federal court really love our courthouse. They love the traditions that we have and the formality that we keep. And, I feel we've lost a lot of that. I'll do settlement conferences sometimes, and lawyers will not be dressed appropriately. And they think it's perfectly okay to show up in a sweatshirt or just a shirt with no jacket, no tie. Their clients sometimes are even less dressed than they are. And it does, take away from the formality of the proceeding. It is a serious court proceeding. I'm in a tie, I'm in a jacket, I'm here with you. I expect, some degree of people to respect the traditions of the court. So I do worry about that. And I caution, a lot of young lawyers, just because you're at home in your bedroom, and it may not be, the most important hearing in the world. It may be a status that will take 2 minutes, or maybe a settlement conference, which is not on the record and a little bit more informal because you're in separate rooms with the judge speaking off the record. Don't treat it any different than a real court session. And make sure your client knows that too. Make sure your client knows to put the dog in the other room so it's not barking through the whole thing, to not, go to the kitchen in the middle of the conference. You wouldn't do any of that if you were in the courthouse. So, treat it the same way.
Hey, Matt, can I follow up on?
Yeah,
can
please
I follow
do.
up?
Please do.
I short-circuited myself on the question, but I just wanted to add that a couple of things that certainly following up on what Mary has said, as well as Sunil, is that being unprepared, just in general, for your hearing is somewhat upsetting because you're ready to go, you want to have it meaningful, and if somebody's not prepared, you just really can't accomplish as much as you want to prepare. And the other thing I would add is the issue of incivility or civility. And that is that young lawyers who are some of the audience here, always remember, kind of following up a little bit on what Sunil was saying, you not only is it a court proceeding, but because it's a court proceeding, you also want to be professional, you want to be courteous, and you want to be civil with each other and avoid any incivility because that doesn't benefit anyone. So I just wanted to add those two things.
So one of the questions that was asked, would there be anything to be said about having some sort of a set of rules for how to behave in virtual proceedings? I vote no on that, but I don't know if anybody's got any thoughts about whether there should be anything published about these kinds of things.
I think it would be, do what you would do if you were live in court. That's, I think it's one rule.
It boils down to right. You pretend like you are in court because actually you are. Just because you're on the phone doesn't mean you're not in court.
Right.
So a question from the audience, which is not too much of a segue here. So I'm just going to read it. It seems oral argument is becoming less common. Decisions are increasingly reached based on the briefs. Is there any circumstance where lawyers should specifically seek out oral argument, or are there some issues that are better presented with oral argument? I have to quarrel with only one thing in that, and that is that this is anything like a trend. I think this is been kind of a common, if you want to call it beef, going back to, frankly, when I was practicing law, which is a long time ago at this point. So, but are there, so just the positive part of the question, are there particular kinds of things that somebody should be asking for oral argument are? And just to follow up on that, does it make a difference to you in deciding whether to hold argument on a motion that somebody's asked for it as opposed to just remaining silent on that? Why don't we start with Judge Harjani on that one?
My response would be, if you want an oral argument, don't be afraid to ask for it. Lawyers do ask for it, and I always grant it because I understand there's something they wish to tell me, or they wish to make their pitch in person. I think they deserve the opportunity to do that. I just don't see the request very much. And we order briefings so we can get all the arguments. You assume that it's all in there, unless they tell you otherwise. So if you want an argument, I would say ask for it.
Worst anybody can do is say no, right?
Right.
Yeah. Judge Rowland, any thoughts on this?
No, just that it's really different because, we used to, before the pandemic, you'd file a motion and you'd notice it up for 3 days later and you'd be in court. And then the judge could talk about it with you and maybe rule on some part of it. Certainly if it was discovery, Judge Harjani, you might say, oh, yeah, I'm granting this part. Oh, I need briefing on this part. You might talk about the motion to dismiss some part of it, ask for briefing on part of it, but now of course we don't allow noticing up because of the pandemic, and so automatically things get set for briefing. Some get set for briefing that you don't really even necessarily want briefing on, and so I think keeping people out of the courtroom, cutting down on people coming into the courtroom, even though there's cost savings, has, at least in my more limited experience, has led to more briefing, which is not cost saving, of course. So I don't know how to, I would like to do more argument, but I have not figured out how to roll that into my daily routine.
I'll tell you from my own perspective.
You tell me, because by the time I get a memo from my clerk about something, it's already, it's kind of, I've lost the opportunity to have an argument on it almost.
Just on a specific slice of things, I will tell you that I essentially never asked for or even took briefs on discovery motions. I think I had it in my procedures from day one. Don't brief these things, just come into court and argue them, because as you say, everybody was automatically coming to court. Usually there's simple questions, the 3 days notice or whatever it is going to be enough. I honestly, I have to say I've changed that. I still do it sometimes, but it's more common for me now to say file a response to that, and then we'll have argument, a couple of days after that, and I reserve the right to cancel it because sometimes the questions are answered. But it's aside from that, I don't think there's really any kind of clear categories of things. I mean, I tend to set it more often when it's kind of a big question or something really more significant, as opposed to, your average kind of summary judgment motion where it's just a question of, whether there's a disputed fact or not. I don't know, Judge Valderrama, do you have any thoughts on this?
I do, Matt. I did a lot of oral arguments in state court on contested motions. The parties, and I think they just from having appeared in front of me, just got used to asking for oral argument, or conversely, they knew if they didn't ask, I probably wouldn't give it, but the majority of them did, and I almost always granted the hearing and had oral arguments on dispositive motions. And coming over, I've not done that nearly as much as I did before, and I do think more sooner than later, I would like to get back to having more argument on substantive matters that I'm presently doing, because I think it helps me. I can ask questions, and I just feel like I can sometimes help resolve the motion better that way. Now, that's not to say that I won't read the briefs, and then I can still have the parties come in after I've read the briefs and said, I have questions, and I'd like to set this over for a hearing based upon my reading of the briefs. So I've done it both ways, but I've not gotten, like Sunil, I've not gotten any motions necessarily asking for oral argument.
Yeah. I think if I can add, it's just interesting because I think what we're trying to do is we'll have to find a balance between the virtual and in-person, and we really haven't found that balance yet because we're just starting to open up. And, to go from 100% in person on every motion because of the notice of motion to 100%, briefing most things because we weren't seeing people. I think there's got to be a balance somewhere in between because I think we would agree that not every motion really required an oral argument. There are some things that are just so simple that really didn't necessarily need, full-blown argument. versus maybe, you know, a quick response brief, or just talking to somebody on the phone, if you will, not necessarily an argument. So I don't know what that balance is, but I think it's some degree of triaging that we will need to do to figure out when the right time is for argument.
There's one question I'm going to just put and then try to answer. And if anybody knows a better answer than I'm going to give, please chime in. One of the questions asked, can a service dog be brought to virtual court if not barking? And the short answer is, I think, of course, when you say virtual, you're talking about doing it from your home. Nobody's going to preclude you from having anyone in your home, or any, you know, service animal in your home that that you need to have there. I will tell you that going back, this goes back a few years, but I've had a couple of cases where I've had litigants or lawyers with service dogs in court. And so I assumed that they were able to get through downstairs and didn't have any trouble about that. So I don't know if anybody has any different answer to that. I transition to the next question. And Judge Rowland mentioned law clerks, and this really wasn't on the list, but we've got a lot of law students on this panel, so it's probably a relatively predictable question. And let's just keep it to a couple sentences each. What are you looking for when you're hiring? What are the qualities that you're looking for when you're hiring law clerks? We'll start off with Judge Rowland. You've hired more law clerks probably.
Writing.
That was 9 writing, so we just looked for 2. But how do you test for that?
Well, you know, I hear that one of my colleagues actually gives a test.
Not me.
They like, yeah, no, not anyone on this panel, sends home a writing assignment, and they have like 24 hours or 72 hours or something to do it. I can't even believe that, but I'm wondering how to do it. I don't really test for it very well, but I've been lucky to get good writers. The thing is, it's a lot of writing. It's a great job. I mostly look for someone that I'm going to get along with, because, you know, I'm a people person. So that's kind of stupid, but that's what I do. And I try to give different kinds of people the experience, because it's just a great experience. And I just want to have a nice chambers where people get along. So that's what I do. And I try to follow the Oscar rules, whatever they are, even though I can't keep track of them. But so I don't interview anyone until that date. And, you know, I try to do all that.
Judge Valderrama, what are you looking for?
Yeah, much like Mary, you know, writing ability is key. I will say that I do prefer some experience, meaning as in the practice of law, before I hire someone as a law clerk. And I know judges vary on this, but I have just found that those who've practiced, at least for a short term, have a better sense of what the practice is. And then when they come and work as a clerk, are also able to cut through some of the motions and the briefs in a faster way, because they've done it. They've been there and they kind of know exactly what to look for. And when you're a young lawyer coming right from law school, right into a clerkship, you're learning all those things. Not to say that you can't learn them, you can, obviously, but it's just a preference. So I would say some experience and good writing experience in particular.
Judge Harjani?
Yeah, like Judge Rowland, Judge Valderrama, I also look for writing and people who have a few years of legal litigation experience, but I really try to find people who are not afraid to debate issues with me. And I really, you know, put time into the interview process to ask them about things they've worked on, and then challenge them on particular legal issues and see how they respond, and see whether they're really able to converse with me about the facts of the law and not break down and not give in when pushed. And I think, you know, we all need that to make better decisions. We all, you know, we always say, you know, clerks save us from ourselves. They help us, you know, see things from a different perspective, and to help us reach better decisions when we're able to talk it out before coming to the answer.
Okay, it's 4:45. So
what do you look for, Judge Connolly?
I look for somebody who's going to write down the CLE code correctly. Since it's 4:45, I'm going to say it, and then I'll give you your answer. Here it is, and I'm looking at the numbers. We're going to see if they drop off a cliff after I give this. 22207. That's 22207. That's the CLE code. So my answer to the question is, I would say pretty much all the above. You know, even when people were virtual, it's a small office. You're working very closely with people. I definitely interested in people that are nice people who you can get along with. Looking for people who know how to write. It is very hard to interview and test for that. I'm not the person that does he's not the only one. He's the only one in this district, I think, but there's others in other districts. I don't actually do a test. I've actually thought about it, but and actually another benefit, as some would say, was that it would probably cut your applications from 400 to about 50. But and then, you know, and as Judge Harjani says, and I think it's a really important point, is that, you know, you don't want people who are yes men and yes women. Your job, you're the judge's lawyer, and the job of a lawyer is to tell the client what you think the client should do and when you think the client's doing something wrong. And so all those things are really hard to interview for. I've been very fortunate too, but it's all tough. Let me go back to a question or two. So we're getting down to our last, pardon me, 15 minutes or so here that I had in fact circulated to people in advance. So so if you could go back to when you were a brand new lawyer, what's something that you learned later that if you'd known it before, it would have helped you? That's probably an awkward way of putting it. Something that you learned later in your career that you wish you'd known earlier. Let's put it that way. And if I get very pensive looks from everybody, I will know that is a rotten question, and I'll move on to the next one.
I have something to say.
Go ahead.
About that. And this might be partly gender based, but I would say this, you know, I got my best advice I ever got was from a court reporter, and I was not speaking up enough in court, loudly enough. I mean, I was speaking, but I wasn't speaking loudly enough, and she was not getting what I was saying down. I was in a magistrate judge courtroom, so I was being recorded as opposed to being heard live. And she was doing a transcript, and she called me up and she said, Mary, you have to elbow your way to the podium. And that's figurative. It also was literal in that sense. She needed me to be closer to the microphone. But when you're a young lawyer, you know, you have a lot to learn. You have to ask a lot of questions because you don't know the answer. And it makes older lawyers nervous if they work with somebody who doesn't ask them any questions, because they think that person doesn't know anything and they're not asking me questions. And that used to make me nervous when I was more experienced. But you also have to speak up and not be afraid to say, hey, what about this for an idea? And just speak up sometimes. And this isn't just a male-female thing, but it can happen where women don't speak up and assert that they have a good idea. And we just lost our moderator. But I'm here.
It just told me my webcam disappeared. So I'll just.
Okay.
That's because he has the call, so he took off.
Maybe that was the the feminist in the sky. But I just want to encourage you to, you know, to speak up, to volunteer to go to court, to be the person who talks to the client, you know, whatever it is, whatever context you're in, because that's what gets you experience and that's what helps you learn. And you're going to make mistakes. And then you clean up your mistake and all that. And I think that's hard for young lawyers to do. So I wish I would have done more of that when I was younger, and I encourage you to do it. And you'll make mistakes, and that's okay.
Anybody else? By the way, my computer is telling me I don't have a webcam. We all know this is not true because you saw me for an hour and 48 minutes. So I blame the tech people. They're always convenient scapegoats. But I'll just continue to participate as a box. So it's easier on everybody's eyes that way anyway. So.
I think we're far enough into the pandemic that you should have your tech figured out by now, Judge Canelli.
It just happened. I mean, it's telling me unable to. Anyway, so does anyone else have anything they want to add to that question?
Judge Valderrama's really ticked off right now, by the way, because this is one of his pet peeves, as he mentioned.
I'm so sorry.
You know,
had I been the moderator, I would have booted you already.
There you go. Please don't hold me in contempt.
But I can follow up, Matt, very quickly, though. I think Mary makes a great point, and that is, you know, and if you think back to law school, the asking questions, right? Asking questions, the fear of I'm giving away my lack of knowledge. I'm giving away my lack of understanding because I'm asking questions. Not so. I think that when you ask questions, you really engage with the judge. You engage. I think what I would have learned would have been nice to know is go ahead and ask questions. It's okay to ask questions. Don't be afraid to ask questions. And no one is going to think you're dumb for asking these questions. One of the things I do with my externs, and I do have externs, and I tell them, you know, if you have any questions, there are no dumb questions, just ask the questions. And I tell them, though, I'm not going to try questions out. This is not law school, but if you have a question, I'm going to try my best to answer the questions. And inevitably, the person sitting next to you had that same question. They were just afraid to ask it. So I think it's just asking questions is a great step to, or a piece of advice of what I wish I would have known, or someone had told me when I started out.
Yeah, I agree with both judges. What I would add is, I wish, someone had told me just directly, that EQ is just as important as IQ. That, you have to have good common sense, good judgment, the ability to make relationships with people, whether it's the client, opposing counsel, the judges, people in the bar associations, just be able to empathize with their positions, be civil. A lot of the kind of the EQ skills that we all have are just as important as being, really smart, being a really good writer, doing excellent legal analysis. That alone is just not enough to make you a successful lawyer. And so rely upon all those EQ skills that you do have, because they are just as important, whether it's, building a book of business or, making relationships with opposing counsel that next thing you know, become your co-counsel or they refer you business. There's just so many ways in which we all interact and interconnect, and you kind of have to be aware of that as you go forward in your career.
Yep.
Uh-oh.
No volume. No volume.
There we go. I'm going to ask Judge Valderrama to vacate that sanctions order because I've signed in on a different device.
Consider it done.
All right, thank you. I was ready to get out my checkbook there, if people even use those things anymore. Okay, we're down to kind of the last few minutes here, but what are the toughest types of matters, issues, disputes, questions, et cetera, that you have to deal with as a judge? Or alternatively, what's the hardest part about being a judge, and what is it that makes them the toughest thing? So we'll kind of start let's start with Judge Harjani on this one.
I'll save the one that I think the other judges will talk about, which is probably sentencing or sending anyone to jail. I think the one that I think about a lot is in the criminal context. It is authorizing a search of someone's house. And having been a prosecutor, you have a pretty good sense of what that entails. It is agents getting up at 6 in the, getting to your house at 6 in the morning, knocking on your door. And essentially there's a team of 5 or 6 of them, and they are authorized to go to any place in your house, really, these days, to look for evidence of the crime. And that, if you can think about your own home and you think about the government intruding on it at 6 in the morning till about 11 a.m., searching through every personal item that you have, taking your computers, your thumb drives, looking at your cell phones if authorized, that is a massive invasion of your privacy. And I am usually asked the day before, 2 days before, to authorize something like that. And so I take that very seriously. It is not a decision that, even though it all happens fairly quickly in terms of the time frame, getting the affidavit, reviewing it, signing it, may happen in the course of 4 to 6 hours. I put a lot of work into making sure I get that right, because I know the consequences of it for some family out there I've never met is going to be so severe at 6 a.m. in 24 hours.
Thanks, Judge Valderrama.
I think Judge Harjani was right to preface it. I find sentencing to be the most challenging aspect of what I do. and for different reasons. Number one, in a case where incarceration is very much a reality, you're dealing with the decision of incarcerating someone, understanding what that means, understanding that that's going to involve separation from his or her family, and certainly depending on the length of time, the time frame that's going to disrupt that family unit. Is part of that decision-making process. The history and characteristics of that defendant come into play, and sometimes they're very challenging in terms of their history and the characteristics and their background. And you're trying to balance and weigh all of those things and trying to arrive at a sentence that is just. So I find sentencing to be, thus far, to be the most challenging aspect of the job for me.
So since I'm making Judge Rowland answer this third, you're probably going to say everybody's already said your thing, right?
Well, I was trying to think of something else. Can I just say that?
That's fine.
I mean, I think that's really hard. I also find it really hard to throw a case out. There's a lot of people bring discrimination cases, and at the end of that, the defendant often moves to say there's not enough here to go to trial. I won't bore the audience with the details, but the thing is, the person feels they've been discriminated against, and the law is hard. It's hard to get a trial. It just is, whether I agree with that law or not. And I find that hard to say to the person. I mean, it's just an order. I'm not looking them in the eye like at a sentencing. And sentencing is by far the hardest thing we do, and it should be the hardest thing we do. And I agree with both the other judges about that. But I do find it hard to say to somebody, look, I know you feel like your employer was racist or sexist or whatever it is, discriminating against you, but you don't understand under the law, you don't have a case. And I don't like doing that all the time. Partly that's because of the kind of law I practiced. And, I want people to walk out feeling like they got heard and they respect the law, even though they're losing, their case is getting tossed. And I find that kind of tricky. I don't like doing it.
I'll give a subset of what Judge Valderrama talks about in its particular types of sentencing. So an awful lot of what we do here in federal court in terms of sentencing in criminal cases involves cases where there's no direct victim. So it might be a gun possession case where there's nobody who got shot at, or it might be a drug case where there's all sorts of indirect victims but no direct victims. I think for me, the most difficult types of sentencings are the sentencings where there's a direct victim who is also involved in the proceedings. Because both sides are asking you for things that are oftentimes polar opposites, and it's really hard to take all of that into account in a way that deals with everything that you need to deal with. And often what you end up, at least what I find myself end up having to do, is some of the goals get minimized and some get maximized, and that's not always the same in every case. So I just find those really super difficult. I will also comment that this device, even though I am an old person, this makes me look 5 years older than me. Not that old. We are right at the end of this, so it's 4:58. There may have been a couple questions that came in after I had to change devices. Unfortunately, on the new one, I wasn't getting it. Apologies for that. So I'm still back on bad paper with Judge Valderrama because my text stinks. But I want to thank Judge Rowland, and Judge Harjani for participating today and taking time out of your days. Thanks to everybody for signing on to the conference, and hope Judge Rowland gets better soon. And we'll sign off. All right.
Thank you, Matt.
Thank you, everybody. Thank you.
Thanks, everybody.
Bye, Mary.
Bye-bye.